BABASAHEB Ambedkar College.
Good afternoon, Honorable Judges of Bombay High Court, Nagpur Bench, Justice Shri G. A. Sanab Sir, Justice Shri M. W. Chandwani Sir, respected Principal Shri Ravi Shankar Moore Sir, our esteemed guest for today, Shri Ajay Chauhan Sir, guest of the day, respected Pravina Khobragade Madam, respected Adhara Deshpande Madam, faculty members and dear students. Good afternoon to everyone. On behalf of Rashtra Sant Tukroji Maharaj, Nagpur University's Dr. Babasaheb Ambedkar College of Law, it is my immense honor to welcome you all to the 22nd JUSTA CAUSA's National Moot Court Competition 2025. This prestigious event, which is being conducted in the centenary year of the year, has been a platform for showcasing legal brilliance, intellectual acumen, and the art of advocacy. We are privileged to have with us today the distinguished panel of judges of Bombay High Court Nagpur Bench, who, with their vast legal knowledge and experience, will undoubtedly elevate the proceedings and inspire us all. I extend a warm welcome to the judges. We are grateful to you for your constant support and for taking the time to join us today. To our participating teams, you have demonstrated remarkable skill, dedication, and resilience throughout this competition. As you present your arguments today, I encourage you all to seize the opportunity to engage with legal principles at the highest level. We look forward to witness the intellectually and thought-provoking the final round of the National Moot Court competition. I wish the teams the very best of luck. Thank you all.
Thank you so much, ma'am, for your warm words.
Moving forward, Our esteemed panel of judges includes individuals of extraordinary legal acumen and experience who have contributed to the field of law. Celebrating our traditions of honoring esteemed guests, we now proceed to a moment of special recognition. It is an honor to introduce our first judge from the panel, Honorable Sri Justice Govind Sanap sir. Born in a farmer's family in Vashan, Maharashtra, his lordship pursued his education with excellence, completing his LLB in first class from Sitabai Arts and Law College, Akola. Enrolled as an advocate, his lordship has practiced civil and criminal law before beginning his judicial career as a judge of the Small Causes Court, Bombay. His lordship has held several prestigious positions, including presiding officer of the Special TADA Court, where he delivered the landmark judgment of the 1993 Mumbai serial bomb blast case, and conducted proceedings in the 2611 Mumbai terror attack case. Elevated as an additional judge of the Bombay High Court, Sir continues to serve with distinction. It is an honor to have you today, sir. I request Dr. Ravi Shankar Moot sir to felicitate Honorable Sri Justice Sanap sir, Judge at Bombay High Court, with tokens of gratitude and appreciation. Thank you so much, sir.
It is time to introduce our next judge from the panel, Honorable Sri Justice M.W. Chandwani sir. An esteemed member of the judiciary, was born in Gondia. Beginning his legal career in 1996, his lordship specialized in criminal, civil and taxation matters before being appointed as a direct district judge. Over the years, his lordship has served with distinction as district judge in Mumbai, Nagpur and Pune, as well as CBI judge handling several high-profile cases. His lordship has held prestigious positions including Principal District Judge Buldhana, Registrar at the Bombay High Court, Principal Judge of the City Civil Court Mumbai, and Registrar General of the Bombay High Court. His lordship elevation as an additional judge of the Bombay High Court reflects his exemplary service and commitment to justice. It is an honor to have you here today, sir. We now request Sri Ajay Chauhan sir to felicitate Honorable Sri Justice M.W. Chandwani sir, Judge at Bombay High Court, with a token of appreciation.
I now request our principal, Dr. Ravi Shankar Moot sir, to felicitate Sri Ajay Chauhan sir, Member Management Council, Rashtra Sant Tukdoji Maharaj, Nagpur University, with a token of appreciation. Thank you, sir. Now, the moment we have all been waiting for, the final round of the National Moot Court Competition 2025 is here. We request the participating teams to approach the dais and commence the proceedings. We wish all the participants all the very best.
If your lordships permit, may I please state the facts of the case? Much obliged. Your lordships, the facts at hand can be divided into two things. First, what is VCW and what is VCW and B? Are your lordships with me? Much obliged. VCW is a local business established 100 years ago, and it has expanded in the state of MP also. It has been also adopted as a company under Companies Act 1956, and the domain name that is now in dispute in this case has also been used by VCW for a very long time. VCW is a tea vendor who works in the court precincts. So it has a very distinct business model. While considering that, VCW and B is a business located in a foreign country. That business has expanded. However, doing that, Makex is a parent company which took over the VCW hedge fund capital company, and then also took over BBT, that is Burger Baron Taser, which was VCW and B initially was Burger Baron Taser. However, there was a cryptocurrency scandal happened that in the state of America, because of which they suffered a big loss and they had to adopt a name VCW and B to change their identity and boom their business. While doing that, they also entered in the market of India, and in the market of India when they entered, they needed a domain name. However, when they checked up online, www.vcw.in, that is right now in the dispute, was already taken up by our petitioner, that is Vakil Chaiwala. When they came to know that, they went ahead and took over two different domain names, that is www.vcw.com and www.vcw.co.in, to start with their business. After doing that, after a time in the year 2021, they filed complaint under NIXI. NIXI is a body which governs the domain name disputes as well as renders domain name. They filed a complaint under NIXI stating that their domain name, the domain name that is in dispute is taken by cyber squatting. Cyber squatting is illegal according to the trademark as well as Indian the provisions that govern .in domain name, that is INDRP provisions and INDRP rules of provision, rules of procedure. While stating that they alleged VCW, authentic domain name, we can say prior use domain name, they accuse them of using domain name in bad faith as well as using it as a cyber squatting. Now we have a dispute over this domain name, exactly who holds the domain name in a legitimate course of event, as well as who is there any involvement of bad faith, and the arbitration proceeding that has went ahead. As I mentioned earlier, the VCW and B already had filed a complaint, and there is INDRP provision that after filing complaint, it goes for an arbitration. Arbitrator has passed an interim order stating that VCW.in will be injuncted, that will be terminated for time being till the final award is passed. And this is the entire case till now, that some of the points of arbitration as well as the further appeals and writ petitions that Vakil Chaiwala filed in the various jurisdictions of Indian territory are now in the dispute. VCW and B approached Supreme Court, and Supreme Court has ordered to club few matters, and those matters will be adjudicated by the Bombay High Court Nagpur bench. These are the facts at hand. If your lordships are satisfied, may I move ahead with the statement of issues? Much obliged. Your lordship, statement of issues, if you may come to the page number 10 of our memorial for the petitioners. Your lordship's memorial for the petitioners, the blue one. The statement of issues are arising out of arbitration first, whether non-granting of personal hearing is permissible. Are your lordships with me? The second issue is whether NIXI could have appointed the arbitrator in the view of statutory scheme of Arbitration and Conciliation Act and requirement of a formal agreement. Page number 10, your lordships, of the petitioner's memorial. So these are the issues that we are adjudicating upon. First one is arising out of arbitration, and there are three sub-issues. First, whether non-granting of personal hearing is permissible, whether NIXI could have appointed the arbitrator in the view of statutory scheme of Arbitration and Conciliation Act and requirement of a formal agreement, and whether the impugned interim order is maintainable. Second and third issues are as following: whether use of trademark by VCW is proper as per the scope of Trademark Act under section 134, arguments before High Court in writ under Article 226, and commercial appeal under section 13. Your lordships, if you are satisfied, may I move ahead with the contentions in the matter? Much obliged. Your lordships, I will be dealing with the issue number 1 and all the sub-issues thereunder, and the co-counsel will be dealing with the issue number 2 and 3. Your lordship, the first issue at hand, the very first issue is the grant of personal hearing. If your lordships may come to the Moot memorial, para number 8. In the para number 8, if your lordships may focus on the fact that personal hearing, the fourth line from the bottom. By way of an interim application, a personal hearing was specially called for by our petitioner, in the case Vakil Chaiwala. Mr. Cranberry, who is arbitrator in the case, denied the same, stating INDRP and INDRP rules of procedure. However, your lordships, if you may come to the INDRP rules of procedure, your lordships are provided with the INDRP rules of procedures. Therein, Rule 16 is in the dispute, your lordships. In-person hearings. So, your lordship, there is mentioned that there shall be no in-person hearing, including hearing by teleconference, video conference and web conference, unless arbitrator agrees on request of either or both parties that such hearing is necessary for deciding the complaint. In event a personal hearing takes place, the same shall be subject to maximum 2 hearings. Here it is clearly mentioned that even though personal hearings are exceptional matter and they are adjudicated under the discretionary power of the arbitrator, however, if the matter at hand is complex and it requires or it calls for a personal hearing to adjudicate upon and for a clear understanding of the matter, there is a requirement of personal hearing. Your lordship, our petitioner was earlier given the chance for written submission. We don't argue on that point. However, now I would like to establish why a matter was complex to understand and there was a dire need of in-person hearing which arbitrator denied us, and there was a procedural lapse and clear-cut violation of principles of natural justice. What does principle of natural justice says? It says that audi altum partem, both the parties must be given the equal chance. While giving the equal chance, when the party petitioner here, VCW, asked for in-person hearing to clear the matter, arbitrator denied without even considering that there is a complex factual matter, and that led to impugned interim order, which I will explain in the subsection P, that how that order is passed without application of mind. Your lordships, if you may come to the moot problem. Vakil Chaiwala is a business that is established 100 years ago. The trademark is acquired in 1983 only, and it has been renewed over the period of time also, every now and then. While doing so, IN.in domain name has also been used by VCW, that is a petitioner, for a very long time, even before the learned respondent VCW and the enters the market of India. This states the principle of prior use, and principle of prior use has been held in various cases, which I will be dealing forward, and I will provide you the copies of such precedents also. Your lordship, we must understand that who was holding the domain name first. The VCW is clearly holding that domain name earlier, much earlier than VCW entered the market. When we consider the principle of prior use, we must understand the case of Travancore. Travancore Ryan. If your lordships may come to the page number 2, held, in the head note, held part, the word the court has held. For the convenience of your lordships, I have highlighted the part. There is clear mention that where complex and difficult questions requiring familiarity with technical problems, as in the present case, are raised, it would conduce better administration and satisfactory disposal of the grievances of citizens if personal hearing is given. As I am stating, there was a principle of personal prior use. Principle of prior use is established in the Tata Motors case. that was adjudicated under INDRP provisions only by arbitrator. I will just give you the facts of the case. If your lordship ever have heard the Harrier automobile that Tata launched, Harrier. Harrier is the car that Tata Motor launched. Harrier was a name that the respondent in this case was using much earlier than Tata Motors. When the arbitrator got notice of this, arbitrator passed this order. For the convenience of your lordships, I have marked the order. If your lordships may come to the decision of the court, which is on the page number 40. This discussions and finding what arbitrator exactly has found. On the 15, I have highlighted in the very bottom paragraph that in the foregoing discussion, complainant has failed to satisfy this tribunal, the respondent does not have prior proprietary right. So, Tata Motor failed to prove that respondent was not using the domain name prior to Tata Motor. This entire case is based on the principle of prior use. In this case, arbitrator allowed respondent to go ahead and use the .in domain because it was using much earlier than Tata Motor. So Tata Motor had no legitimate right to go and file a complaint to cancel or transfer the domain name. So this very case clearly establishes the principle of prior use, which is our very basic contention that our domain name was acquired much earlier than VCW and B, and when VCW and B was not even in the market of India. When we contest that, if personal hearing would have been provided, we would have been able to pursue the arbitrator and tell that our case is on the basis of principle of prior use. The arbitrator did not provide us a chance to orally argue what our contentions are. Written submissions were insufficient. They did not convince the arbitrator, and that led to a procedural lapse and violation, clear-cut violation of natural justice, principle of natural justice. If arbitrator would have taken the small note of complex matter and given a chance to in-person hearing, he would have understood that there was no need to pass an interim order stating that the domain name shall be terminated till the final order is passed. We are now getting injured because of this interim order, that we are unable to use that domain name whatsoever, and our entire backend server is run on that domain name. Yes, Your Lordship. Yes, Your Lordship. Yes. Yes, Your Lordship. Yes, Your Lordship.
Now, it is not that you are the responsible to matters which have been right number one.
VCW is a petitioner. What happened is, earlier when the arbitration proceeding was initiated, that time VCW and B was petitioner, rather complainant we may say, and then the further writ petitions and commercial suits were filed by VCW. VCW and B. Yes. Yes, Your Lordship. Your Lordship, there is a discretionary power that is given to arbitrator, that he may give in-person hearing if there are complex matters. What? Yes, Your Lordship. No hearings shall be held. Your Lordship, when I pointed that out in the Moot proposition, that interim application was filed by VCW. When the return submissions were filed by VCW, we also went ahead and filed an interim application stating we need in-person hearing. However, arbitrator clearly denied that, stating INDRP and INDRP provisions, which was an insufficient reasoning. Your Lordship, there also is a procedural lapse. However, I am coming one by one on the point that there was clear principle of prior use. We were the holders initially, way before the VCW and B entered the market. Second is, as I mentioned, arbitrator has failed to mention the reason, exact reason why he denied in-person hearing. When it comes to administrative authority adjudicating upon any case or a quasi-judicial body, they must provide a reasoned judgment while passing an order. However, by just merely stating that under INDRP and INDRP procedures, we are denying the right of in-person hearing, he has not taken into consideration the complex matter. We are stating we have a prior use. If we have a prior use, that leads to no bad faith. Your Lordship, bad faith will involve if we are trying to sell that domain name. We have absolutely no intention to sell that domain, and that is highlighted from the fact that we are running entire back-end service. We have currently more than 8,000 employees. Currently, it is expanded out of Maharashtra in the state of MP also. While in this scenario, if we are running such a big back-end service on our domain name, we have absolutely no intention to sell it off to a third party. That
you relied on the case of Travancore Ryan Limited.
Yes, Your Lordship. Complex factual matters are involved.
Requiring familiarity with the technical problems.
Yes, Your
How
Lordship.
you will find your case within these words, because your claim is that prior use here.
Yes, Your
Whether
Lordship.
in that case it will be complex, difficult question requiring formality with the technical problem.
Your Lordship, if the written submission would have been sufficient, the learned arbitrator won't have passed an order stating the termination of dot-in domain. That clearly states that arbitrator did not really understand the factual metrics of the case. If he would have considered the factual metrics only based on the written submission, he would have simply understood that our case was of principle of prior use. There was no involvement of bad faith. We had a legitimate interest. What legitimate interest is? That we were using for a legitimate business purpose. We were running our entire backend servers. There were no illegal activity that was getting held on the under the domain name. This all clearly states. Arbitrator. Why I stated that is because if you will observe all the cyber squatting cases, most of the cyber squatting cases get disposed of in the favor of complainant, stating that complainant has right over the domain name more than the respondent. A lot of times complainant gets the favor than the respondent. However, in this very case is very much special. What is happening is the VCW and B is not even an Indian company. It is some foreign company which has entered in India. If there are too many, a lot of things are involved, not just prior use, but which company is asking for, exactly who holds the trademark, who has a trade, is there any trademark infringement? We have to adjudicate upon a lot of questions. Is there involvement of bad faith? Are the parties holding legitimate interest? We must understand the fact that both the parties hold a registered trademark. In that case, who exactly holds the legitimate interest for domain name? That is also essential part to adjudicate upon. Not just one, but 10. There is a list of 10 things that an arbitrator was supposed to delve into, which he has clearly overlooked. If he would have given in-person hearing, it would have been easier for us to state that. What are the grounds that arbitrator has missed to adjudicate upon? This is the reason why we are stating that the non-grant of personal hearing was in the clear violation of natural justice, and that has led to not applying mind while passing the interim order. This is the only reason why we are stating that the metrics of the case are very much complex and we should have been given right to in-person hearing. Are your lordship satisfied with the first issue? May I move forward with the second? Much obliged. Your Lordship, second issue at hand is appointment of arbitrator by NAGPUR. This is very interesting. Your Lordship, when we file a case under NAGPUR, NAGPUR is the authority who goes for an arbitration proceeding as well as select the arbitrator. While in the Arbitration and Conciliation Act, your Lordships may consider the section 11 of Arbitration and Conciliation Act, which talks about the appointment of arbitrator. And appointment of arbitrator is appointed through parties' consentment. So entire Arbitration and Conciliation Act is based on the fact of party autonomy. Whether I want to go for arbitration, whether I want this as my arbitrator, party comes to a consensus. If party are not able to come to a consensus, then the judiciary will adjudicate upon. Party can approach judiciary and then go for an arbitration proceeding. But there is clear violation of this. Party has given absolutely no chance to understand whom to choose as an arbitrator. NAGPUR has unilaterally chosen arbitrator on the behalf of petitioner or in this case petitioner, and clearly violated the principle of party autonomy, which is the crux of entire Arbitration and Conciliation Act, which is in the section 7, that is the agreement, what is arbitration agreement, and section 11, appointment of arbitrator. Both the sections states that there must be party autonomy and there must be